The following program, offered by Fox 19, includes lawyers licensed in Kentucky. For those lawyers to maintain compliance with the Kentucky Bar Association requirements, the phrase, "This is an advertisement," must appear on the screen. Moore Law is underwritten in the public interest by the Moore Law Firm, a legal professional association. This is Moore Law on Fox 19.
Good morning. You know, slip and fall is the common term for a broader legal area called premises liability, which holds that owners and occupiers of property may be legally responsible for accidents and injuries that occur on that property. Have you been injured due to somebody else's negligence? How can you be sure if you have a claim? If you have suffered an injury at a home or business due to unsafe conditions on the property, give us a call, and of course, as always, we will take your questions live. Good morning, Don Moore. How are you?
Morning, Deb. How about you?
I'm good. I know that you did a lot of driving over this long weekend.
I went down to a family farm in South Georgia, and I ate enough turkey for both of us.
So you should have walked back?
I should have jogged back.
All those miles?
And I might have gone faster than I did on I-75.
Oh, well, maybe we'll go hook up with Rob Williams over at the gym later on.
I need to do that real bad. Hey, we have a great guest today, Michelle Young. Welcome.
Hi.
It's good to have you. Michelle has been practicing for over 20 years. She has taught at 2 different law schools. She has written and done work with the Court of Appeals, and she practices law with her husband, Greg Young.
And you do all that, and you have 5 children that you run around everywhere.
Every weekend,
Wow.
One sports game or another.
I have 2, and I don't know how we get them where they're supposed to be, let alone 5. So, well, welcome. Thanks for being here.
Thank you for inviting me.
You know, let's start off a question that, you know, what should people know about when is it time to come to an attorney? When, you know, if I fall at the grocery store, is it the grocery store's fault if I slip on a grape or a piece of lettuce?
Well, you have to ask questions of the attorney. So you have to find out where they fell, how long, if there's a grape or a piece of lettuce, how long was it on the floor, and you have to see if you're injured. But if you have a question, I think it's always good to call. Consultations with most lawyers are free if they are personal injury or liability premise attorneys.
So people shouldn't think I don't want to call anybody because it's going to cost me thousands and thousands of dollars right off the bat.
Absolutely not.
Okay.
We work under contingency fees, which means you don't pay unless we actually collect a recovery for you.
Okay.
And while we're on that topic, just to finish it off, basically you've got the contingency fee is how much?
It varies, 1/3 to 25% depending on the law firm.
Okay, great.
Okay. All right, let's head to the phones now. First up, we have Tim in Springdale. Good morning, Tim.
How you doing?
I'm doing fine. How are you?
Good. My question is, my mom passed away back in January of this year. She had fell in the house in December, a couple weeks before Christmas, and broke her hip. They sent her to the hospital, and she had surgery on her hip. They released her to go to a nursing home facility, rehabilitation facility and nursing home. And I went over there that day when they released her. Half hour before right before I left, I told them, I said, she's delusional from the medication they're giving her. She's delusional. She's trying to get up out of bed. She doesn't understand where she's at, what's going on. I said, keep an eye on her. And I heard one of the girls say to the other girl, we need to put an alarm on her. Well, I hadn't been home a half hour after I told them that. And they called and said she had fell and broke her other hip. So they took her to the hospital and did a second surgery on her. And I'm not saying that that was the only cause to her death, but I definitely feel like it contributed to her death.
So I guess what we're asking is, does the nursing home have some responsibility, the
Correct.
fact that she fell there?
Yeah.
Yes.
Yeah, that's a great call.
And your thoughts on something for Tim? What is there any recourse for him?
Well, Tim, you have to ask, how did she fall? Was it negligent? Was there a duty of care at the time she fell? Did they follow the procedures that are necessary to protect an elderly woman at risk?
Go ahead, Don.
Well, what I was going to, and you're exactly right, I couldn't agree more, and in a nursing home, it's a real common thing. They've got an elevated duty of care because they have people there who are often impaired, and they don't have the normal faculties about them. So the alarm that you talked about a minute ago, they knew that this person was what they call a fall risk, that is someone who is likely to fall, and the alarm that they can put on the bed or on the person tells them, alerts them when a patient is trying to get up. And if a person has a fall risk hazard, then when the alarm goes off, then they're going to immediately go and assist them so they're not trying to go to the bathroom or doing something, become disoriented and fall. And frankly, a broken hip is often in the elderly a precursor to a cascade of negative things happening. Their health goes down, 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 and then they pass. Tim, last thought. You got 2 years on a straight negligence. You got 2 years from the time the injury occurred or from the time the death occurred. If it's considered a medical malpractice case, you got 1 year. So you're running close on time. If it's med mal, you've got another year. If I understood correctly, this happened in December of last year. So I would have somebody look at it immediately.
Okay. All right, let's get to our next call now. We have Lenny in Liberty Township. Good morning.
Good morning. A year and a half ago, I slipped at a major grocery store, and because of the persistent pain, they encouraged me to go to see a doctor, had x-rays done, and after they reviewed the tape, they saw that it was a bad fall, but they also saw that apparently a child had spilled water, and they felt they weren't negligent, so they didn't even pay for the doctor bills.
Okay, that's another great call.
Can I ask you where this took place?
You said just a major, you said a grocery store?
Yes, a year and a half ago.
Okay.
Right.
Well, first let's begin with the statute of limitations, because that's 2 years. Beyond that, a store does have to inspect regularly to see if there are spills. So the question is how long passed from the time of the spill to the time that you fell. Most stores require about 20 minutes, possibly 30, no less than 15 minutes, I would say, to check to look for spills. And if there was a report, then the duty may actually be sooner. So the question you have to ask yourself is, were there any other witnesses? Did anyone know of the spill? Was there a report made? And if so, how long ago was it made?
Yeah, and that's great advice, Michelle. And in addition to that, in addition to their duty to look, there's two elements there: actual notice that they actually knew that this kid had spilled water and they should have done something about it, or constructive notice, which is what Michelle's talking about. And basically, if it's been there long enough, so you have to prove that it's been there. Sometimes cart tracks through the water is one way to indicate that it's been there for a while. There's one other thing I think you need to know, and that is that even if they didn't do anything wrong, they may have insurance coverage that would cover your medical bills only. That's called med pay coverage. So that's a thought. If they've just denied it outright, then you should probably get advice and have someone take a look at it and decide whether there's actually a case.
And the reason why I asked whether it was a major store is because the major chains tend to self-insure, so they usually do not give med pay, and they're stricter. Smaller stores like a bodega, a little store, will have insurance, and often, regardless of liability, there can be med pay.
Yeah.
Okay,
Great
we
point.
are going to take a break right now. We'll be back talking about slip and fall. Give us a call, 513-421-4691.
Welcome back to More Law on Fox 19, your legal questions live, with local broadcaster and award-winning reporter Deb Haas and Cincinnati personal injury attorney Don Moore, recognized by Ohio Super Lawyers. More answers, more help, more law on Fox 19.
Welcome back to More Law. We're talking about slip and fall injuries today. Our guest, Michelle Young, thanks again for being here. And the phones are ringing, so let's get going on that. Let's start with Tricia in Northern Kentucky. Tricia, you had a question. Your mother fell at a skating rink.
Correct. She fell off an unmarked step at the skating rink. She was not skating, was going to watch a performance. She fractured her wrist, which required 2 surgeries, was off work for a very long length of time. And the skating rink claims to hold no liability insurance.
Is the skating rink liable there?
I'm sorry?
It depends on we have to check to see whether there was a duty of care in terms of the fall, whether there was negligence. When she fell, we'd have to know more about the fall itself.
So maybe just an unmarked step?
Yes, so Michelle, when you say negligence, what do you mean?
A duty to have a standard of care.
Okay.
So it's not enough to fall. You have to actually fall because they failed to meet what we consider to be the standard of care for a skating rink.
So basically, the landlord has to do something wrong.
Yes.
The premises, the one in control of premises, in this case the skating rink.
Yes.
And if they didn't do anything wrong,
Then there's no liability.
okay, even if you've got an awful injury, this is important. It's important for people to know that even if you've got an awful injury, you've got to show that they did something wrong and that caused your injury. So in this case, Trish mentioned an unmarked step. Well, under certain circumstances, possible they did something wrong. Maybe they had it poorly lit and they knew people were going to be there. There could be circumstances that you could conjure up. But from what she told us, it just doesn't have a mark on it. Well, there may not be a duty to mark the step at all. The issue is, did they do anything wrong? If they didn't do anything wrong, then they're off the hook and they don't have any duty, except maybe if they've got medical payments insurance, and medical payments insurance for a skating rink is going to cost a whole lot of money, so probably most of them wouldn't have it.
I
Okay.
agree.
Let's get to our next call. We have Tim in Alexandria. Tim, something happened when you were shopping with your girlfriend this weekend, is what I'm hearing.
Oh, yes. How are you today?
I'm doing fine.
Hey,
How
we're
are
doing
you?
great, Tim.
Good, good. Hey, I was just wondering, me and my girlfriend was out at one of the department stores looking at lawn furniture, and when we were looking at lawn furniture, actually they had displays on the floor, and my girlfriend went and she sat down in it, and actually the bolts weren't all the way tight in none of the chairs, and after I started looking, none of them throughout the store. Well, when she leaned back in this rocker, recliner, spinner, swivel thing, she fell back, hit her head, kind of hurt her neck. It was sore for a couple of days, and also her, just got a real bad headache out of it, but she seems to be all right. Would that be considered like negligence on their part, not having that put together correct?
Your thoughts on that, Michelle?
It does appear to sound like negligence. You do have, they did not put together the chairs correctly. Now, in open and obvious, if it was open and obvious that the chairs were not put together correctly, then there would not be any duty regardless. But because it didn't seem that you could tell by sitting down in the chair that it was going to break on you, then it does appear to be negligence. Beyond that, then the next question is there an injury? Did she go to a doctor? Is it recorded? Because that, you need to have an injury to actually collect on negligence.
And so, Michelle, when you say open and obvious, are you referring to something that an ordinary person should see easily?
Yes, you're responsible anytime you enter any place. You're responsible for looking ahead of you, actually beneath you, and trying to see where the dangers are, whether they're open or obvious. And then if there is one, even if there is negligence, often you cannot go to court for that.
So if it looks like a normal chair and is sitting there for people to use, then it's probably not open and obvious, then it would go back to the store owner, is that right?
Absolutely.
Okay, great.
Okay. We are going to take a break right now. We'll be back. Give us a call, 513-421-4691.